Good morning and welcome to day 2 of IMX 2020. My name is Frank McCormick and I'm the Gulf Coast correspondent for the Waterways Journal based in New Orleans, Louisiana. Thank you for being part of IMX and this timely session, which we've titled COVID-19, What You Need to Know from a Legal Perspective. Before we get started, I want to stop and thank our sponsor for this session, which is Fox Smith Attorneys at Law. And I'd also like to thank all of our sponsors, speakers, and exhibitors who have worked so hard to make this event a success. All of them, along with you, the attorneys, attendees have come together to make this, which is our 7th IMX, a resounding success so far, and thank you. Be sure to visit the virtual expo hall, which is live today and tomorrow from 10 a.m. to 4 p.m. There's a lot of outstanding information available there and plenty of opportunities to network and make new contacts. And also spread the word among your companies and colleagues because registration is free and anyone is welcome. Also be sure to look over the education schedule for today and tomorrow, and don't fret if sessions that you're interested in overlap, because this session, along with all the others, will be recorded and available on this site starting next week. Sessions will be available through the Thanksgiving time period. And now it's my privilege to introduce you to Stas Levchinsky, who's an attorney with Fox Smith, who will moderate our session today. Stas, it's all yours.
Thanks, Frank. Thanks very much. And before we get going, I want to thank you, Frank, and thank everybody at the Waterways Journal, people I've worked with, Jen, Kylie, Spence, Catherine, who's helping with some tech support today. I think it's a credit to all of you for putting this together in pretty extraordinary circumstances. And I think it's really a credit to the industry that we're all able to come together like this. Before we get going, just briefly, I want to say that when Spence and I talked about what I could present on, obviously the topic of COVID-19 is on everybody's mind. And so we started thinking about what it is that people in our industry need to know from the perspective of claims handling, the perspective of liability, and the perspective of risk. So what I'm going to be talking to you about today, and before we get into all that, but I'll talk about the little disclaimer. But what I'll be talking about today is an area where I think the law will be going on COVID-19 as it relates to potential plaintiffs' claims of seamen employees. Before we get into that, if you know you're talking to an attorney when you see something like this, everyone's going to have a disclaimer. What we're talking about today, what I'll be talking about today, is not to be taken as legal advice. As you see from this funny cartoon, this guy's selling it for $5. And if you want good legal advice or accurate legal advice, it costs a whole lot more. Really, that's just to underline the point that legal advice is fact specific, and it's based on analysis of the current factual situation. And if anybody has questions like that for me after this, I'm happy to talk to them about that. And I can also say I'm not going to charge you $5,000 to do that. Getting into what I want to talk about today, it's really 4 main topics. Maintenance and cure, first off, which I think will be the immediate concern for folks running maritime companies, folks in the maritime industry, is how to handle your maintenance and cure obligations when it comes to a claim, a lost time injury related to COVID-19. As you'll see further on in the presentation, this is also probably going to be a long-term consideration as well. Secondly, I want to talk about liability issues that can come up, that I believe will come up, related to COVID-19. And those, as they relate to the maritime industry, are going to be centered around Jones Act negligence and claims of unseaworthiness. These two almost always go hand in hand in any plaintiff's case against a maritime employer, any seaman's case against a maritime employer for damages. I'll talk about the potential impact of liability shield laws And what I mean by that, and as we'll talk about further on, there are laws and executive orders in a handful of states. It's a bit of a patchwork, but essentially what they are meant to do is to protect employers from lawsuits related to COVID that are brought by employees. I'll talk about where I think that may impact the maritime industry, and we'll also talk a little bit about a proposed federal law that relates to the same thing. That has not been passed yet, but it is the only thing that I've seen so far that is out there, and it's possible that it may go into effect in the future. And lastly, I'll give you a few things that I think you should be considering as you go forward in the maritime industry related to COVID-19 to best protect everybody that works in the industry, specifically people that work on these boats. And also that best protects your company from potential liability and risk. Now, before we get into the substance of all this, it'll be another disclaimer. This is not an exhaustive list. It's not meant to be a be-all, end-all of every possible thing you could deal with from a liability perspective, from a legal perspective related to COVID-19. As you can probably imagine, as some of you have already probably dealt with, there are data security issues related to employees who work from home and access the company server. There are just general employment law issues that come up for shoreside personnel, really anybody else at the company. There are insurance coverage issues that some of you may have questions on. Those are not going to be discussed at length in this presentation. We have a great team of attorneys at Fox Smith for just about all of these issues. And so if you have a question related to something outside of what I'm talking about, please go ahead and put it in the question column or shoot me an email or give me a call, and I'll make sure that we can get that answered for you. So getting into maintenance and cure, and before we do that, the reason that I think that this is going to be something that we will have to deal with long term is because there are already, even at this early stage dealing with this pandemic, which is a relatively early stage dealing with this pandemic, there are already known long-term health complications that doctors have seen or believe will occur in people who have had COVID-19, and this goes across the board for people of all ages and all health profiles. If you just look at the Mayo Clinic's website, you look at long-term complications, people have already seen that COVID-19 can cause long-lasting heart damage, even in people who only experience mild symptoms. Obviously, there could be damage to the lungs if you have, or if somebody has undergone complications related to pneumonia, or even worse, if they have had to be on a respirator, and that can lead to scar tissue and long-lasting effects. Medical experts have found that there are issues related to strokes, seizures. I'm probably going to mispronounce this, but I think it's pronounced Guillain-Barré syndrome, which is essentially temporary or medium-term paralysis caused from nerve damage in the body. And there are potentials to increase your risk of developing Parkinson's, Alzheimer's, and finally, there are cases where people have had major damage to major damage to blood vessels related to large or small blood clots, which can have a host of other effects on the body. So it does not take a lot of imagination to see how a half-decent plaintiff's attorney can look at information like this that's publicly out there and make a case for somebody that has some of these lasting issues, so that a doctor will say is likely to have these issues in the future because they contracted COVID-19, and more specifically because they contracted COVID-19 on a vessel or in the service of one of the ships at their maritime employment. So getting into the topic of maintenance and cure, for those of you sitting in on this who aren't familiar with legal terminology and that don't work in claims department or with legal, maintenance and cure is the obligation of a maritime employer to provide for medical treatment and also essentially room and board or living expenses while somebody is receiving that medical treatment for employees, for seamen who get hurt or get injured while in the service of a ship, while they're at work. Now, let me back up for a second. What I want to do with my analysis here and give you an idea of where I'm going with this is lawyers, when they look at these cases, when they evaluate cases, and when they evaluate a claim, do so by looking at previous decisions, at previous case law on the same topic or related to the same incident. Now, we are too early into this pandemic for there to be any substantive legal decisions on this. So what I've done is I've pulled a few cases that I think judges will use as guidance when they make determinations about COVID-related liability claims and COVID-related claims for maintenance and cure. So I want to walk you through some recent developments in the law in terms of where the maintenance and cure obligation has gone and how it has evolved. And the maintenance and cure obligation is centered around an old Supreme Court decision. And essentially what you need to know about it is that most courts will always favor the seaman in a situation where there's a dispute over whether or not an employer owes them money for maintenance and cure. So this is a situation where if there's any close call at all, you can assume that the tie is going to go to the runner, and that runner in this case is going to be the seaman, the employee. Now, this law has evolved a bit to be even more favorable than that, and I'm going to show you how. Going back to 1996, the Sixth Circuit decision is a case called Stevens versus McGinnis, and the underlying question there that I've got at the top here is, must the company pay maintenance and cure only when a seaman's illness is diagnosed during his employment, or must the company pay maintenance and cure to any seaman whose illness causes symptoms during his employment, even if that illness is not diagnosed until after the seaman's employment terminates? Now, this is a case that dealt with an employee for McGinnis who was working for several years until he began experiencing headaches, and his personality began to change noticeably. Witnesses, coworkers testified that he began being more temperamental, more ornery. He began getting into fights with other coworkers. Ultimately, he got fired for that. And then a few months after he was fired, he was diagnosed with a brain tumor. So there was evidence in the case that the headaches he was experiencing while he was at work, the personality change that he experienced while he was at work, were all symptoms of this brain tumor. And when it came to decide whether the company owed him maintenance and cure for something that was not diagnosed until he was not with the company anymore, the court decided to create what was referred to as the manifestation rule. And the holding stated that clearly the seaman experienced symptoms while, quote, in the service of the ship, which made the company obligated to pay maintenance and cure until that employee reached maximum cure. And they also noted that the fact that the seaman didn't seek treatment when his symptoms manifested made absolutely no difference to the court's analysis. So that was an understanding that was in place going 1996 and forward. And this is from the Sixth Circuit, which covers a specific region of the country. What I'll also tell you is that when it comes to maritime law, by and large, the courts will not put a lot of stock into a case being decided outside of their circuit. Courts tend to err on the side of uniformity if they can. So if you have a case, or if your company is involved in a case that's outside of the Sixth Circuit, that's not going to keep the court from applying Sixth Circuit precedent to a maritime law dispute. But as I'm going to show you on this next slide, this precedent actually has evolved and has become even more friendly to a seaman that is involved in a maintenance and cure dispute. The case of Messier versus Bouchard Transportation from 2012 out of the Second Circuit created what's referred to as the occurrence rule. Now, in this situation, there was a seaman that was diagnosed with lymphoma after he was no longer with the company. There was undisputed evidence in the case that the lymphoma, this cancer, was present in his system while he was working, but he was asymptomatic until after he left the company. So I put in quotes there. There wasn't a manifestation like the other decision looked for. So the district court at trial looked at that and said, well, no symptoms manifested. We're going to follow that Sixth Circuit precedent, and we're going to give the company summary judgment. It went up on appeal, and the Second Circuit appellate court reversed. And they held that whether the symptoms manifest when he's in the service of the vessel is not relevant to the analysis. What's relevant is whether or not the illness is present in the system, in the seaman, if it occurs at any time while they're in the service of the ship. And if that's the case, they are going to be entitled to maintenance and cure. Now, they also noted that even if it's a pre-existing condition that's aggravated during the service of the ship, the seaman is still covered unless that seaman actively concealed that condition from their employer on their employment application. So that's going to be key. That part of the decision is going to be key in terms of risk management and protection and how you go about your pre-employment questionnaire with potential employees going forward. At some point, we're going to talk about some of the steps that you can take and some of the things that you ought to be thinking about doing as it relates to this. And that in pre-employment questionnaire, that medical questionnaire, is a key part of all this. So one last case I want to talk about here is Ramirez versus Carolina Dream. This is something out of the First Circuit. It's a little bit more recent in 2014. And in this situation, there was a seaman who suffered a laceration. He had just a cut on his mouth when he hit his jaw on his bunk aboard the vessel. He started feeling dizzy, he started feeling weak and sick, and he went to get treatment. And during that treatment, they found out that he actually has aplastic anemia, which I believe is a condition related to hepatitis C. He had never been diagnosed with that before, and it had nothing to do with him hitting his head or cutting his mouth open. But the court held that that does not matter. It does not matter if there is something, if there's an illness that's diagnosed that's discovered during treatment of an on-duty injury that has nothing to do with the on-duty injury, so long as the condition was not disabling or deliberately concealed when the seaman joined the service of the ship. So in this situation, if Ramirez had known about his hepatitis C, and he's asked about that in his pre-employment physical, in his pre-employment questionnaire, and he conceals it from the company, that changes the analysis. And that is a situation where it's likely the company will not be responsible for maintenance and cure obligation. But if that's not the case, if he didn't know about it and it was present in his system while he's in the service of the ship and it's diagnosed because they're treating him for something totally unrelated, the company will still be responsible for maintenance and cure payments while he was getting to maximum medical improvement. So some key takeaways from maintenance and cure. Like I said before, courts will favor the seaman when there is a close call. They're always going to err on the side of the seaman. It's a long-standing legal principle. So if this is a situation where you're looking at it and you think, well, it's 50-50 whether or not we owe maintenance and cure in this situation, most attorneys who you speak with in those scenarios will tell you to go ahead and pay it. And the reason why we do that is because maintenance and cure is the only one of the three legal claims that a seaman can make against their Jones Act employer. Out of maintenance and cure, a Jones Act claim, and an unseaworthiness claim, maintenance and cure is the only one where the seaman can ask for punitive damages. And those will be damages that are above and beyond damages that he's owed for room and board payments and payments for his medical treatment. And it is usually the specter of those punitive damages that cause a lot of cautious attorneys to say, look, this might be a close call. You may be able to show that this is unrelated to his employment, that these symptoms never appeared. But if it is a close call, the court will probably err on the side of the seaman. And then the court will start looking at you and how you perform this analysis and make a determination of whether you not only kept maintenance and cure from the seaman, but whether you did that in a wanton fashion or a willful fashion. Now, this doesn't mean that an employer is not entitled to investigate a claim, to make some reasonable efforts to find out if what the seaman is alleging is true. They can request medical records, have a doctor look at those, get an opinion from a consultant, things like that. Those are all reasonable steps that an employer is allowed to take when investigating a maintenance and cure claim. And delaying those payments while you perform a reasonable investigation is not usually something that a court will hold against you when determining things like attorney's fees, costs, and punitive damages. But you will have the burden of showing how what you're doing is reasonable under the circumstances. And ultimately, the fact that you are performing an investigation may not take punitive damages off the table in case something gets to a jury. So even if you have a pretty good defense, punitive damages may still be left on the table, and that will also lead to discovery of a company's finances and their assets, and it leads to all kinds of issues that companies tend to want to avoid. So it's usually the combination of the fact that the courts will err on the side of the seaman and the specter of just even the potential for punitive damages usually cause, will usually render the advice from counsel that if it's a close call, go ahead and pay it. Going forward, I think that maritime employers ought to consider adding a COVID-related question on their pre-employment medical questionnaire. If a pre-employment medical questionnaire is not something that you already use, please let me know. We can provide you with an outline of one or something that you can frame that will work for you. But it's something that absolutely every single maritime employer needs to be using if they're not already. And going forward, considering the long-term health implications that are already known from COVID-19, I think that every company ought to consider adding some question that's something like, have you ever been confirmed to have a diagnosis for a positive diagnosis of COVID-19, and whether or not that person has had hospitalizations because of that, or if they had long-term symptoms because of that, things like that. The more specific a questionnaire like that can get, I think the more it'll tell you about this potential employee's ability to do the job and their potential future complications, if any, from their illnesses and their prior medical history. And it's really important for maritime employers to know that, because nobody in this industry wants to put anyone in a position where they may get themselves hurt or where they may get someone else hurt while they're doing a heavy manual labor job, as is a description of a lot of the work that goes on these vessels. So I just want to go through a few quick scenarios then that you may run into in the future when determining a maintenance and cure obligation. So the first, if you can imagine a seaman whose symptoms manifest before they ever get on the vessel, are you going to owe maintenance and cure? And the analysis there is going to depend on what you know about when the last time that seaman was on one of your boats, and if there's any possibility that they contracted COVID-19 while aboard one of your vessels, while in the service of one of your ships. And if that analysis leads you to think that that's a possibility, that's a probability, you may owe maintenance and cure to that seaman. The second scenario is a seaman whose symptoms manifest while they're in the service of the ship. If you can imagine somebody aboard one of the boats is on there for a 28-day trip, and they develop a fever or a cough or body aches, any of the well-known symptoms of COVID-19, you may ask yourselves whether it matters that he contracted that COVID-19 aboard a vessel or if he caught it somewhere else while he was shoreside or while he was with his family, not at work. The maintenance and cure obligation in that situation, that analysis is not going to matter. It doesn't matter where they contracted COVID-19. If they're manifesting symptoms while aboard a vessel, you are going to be responsible for maintenance and cure. And hopefully in most situations, that's not a lot. Hopefully the symptoms are minimal and they just have to take a few weeks off until they get a negative test. But if they have to go to the hospital, if they have to be admitted, if they have long-term complications, you will be responsible for maintenance and cure under that scenario. A similar analysis can be done for a seaman whose symptoms manifest shortly after getting off of a vessel. Obviously, this is going to come down to how good your screening procedures are on and off the boat and how good your precautions are on and off the boat. And we'll get into some of those with later slides. But if they manifest symptoms within a day or two of getting off of a boat, there may be good evidence in terms of just the length of time it usually takes for symptoms to manifest in these cases. There may be good evidence that seaman can rely on to prove ultimately that he did contract it while at work. And if that's a situation, then you will likely owe maintenance and cure there as well. The next scenario, if you can imagine a seaman who is totally asymptomatic, but he is diagnosed with a COVID-related complication that is totally unrelated to one of his work injuries. This is similar to the situation with Ramirez, that case that we talked about before. And this is a circumstance where you are going to still be obligated to pay for maintenance and cure. And finally, a seaman who is diagnosed with a COVID-related condition after he left the company, having tested positive for COVID during his time with the company. As you probably guessed from that second case I brought up, this is going to be a situation where you are obligated to pay maintenance and cure. So it could be years down the line where somebody who contracted COVID while aboard one of the vessels or was diagnosed with COVID after having symptoms while aboard one of the vessels, and years go by and they start suffering some of these long-term heart, lung, or brain or blood vessel, blood clotting complications. If they talk to somebody who understands the law and who gives them, good legal advice on the plaintiff's side, they will be able to ask for maintenance and cure. And if you don't agree to give it to them, they will be able to file a case seeking damages. I've got a question that popped up here from David Murray. Sorry that we can't see each other or talk to each other in this circumstance. I'm going to read it real quick before addressing it here. So David brings up a really good question. I'm going to go ahead and publish it. Okay. I'll go ahead and move that to the published list of questions here. And the question is, are you at risk if you deny boarding to an employee who attended a large event and is asymptomatic because you suspect that they might have been exposed, even if they test negative and or deny that they have symptoms? So this is a question that falls more in line with employment law obligations. And David, I'm happy to have a conversation with you after this to kind of get in deeper into this kind of circumstance. But my understanding, just very broadly, is that you will be allowed to do that. You will be allowed to deny that if you have policies in place that people at your company know about that relate to this. So if this employee is on notice, and what's really important under employment law is that to make sure that you apply those policies uniformly. you don't want to have any situation where, you have one employee who you find out something like this about, and you say, you're not allowed to come in and you're not allowed to, to get aboard one of our ships in this circumstance. But another guy who's in a similar scenario, you don't apply that rule to them. And so what that'll expose you to is a claim that you're playing favorites. You're not applying your standards uniformly. And that ultimately, exposes you to, potential employment discrimination based on, what other factors may be in play. So the short answer is that so long as you have, policies in place that are clear and that everyone's on notice about, and so long as you apply those policies uniformly, I think that you should be in your rights to apply those policies to an employee in this type of a circumstance. So thanks very much for your question, David. And if anyone else has questions, I'll try to get to them as I can, and I don't mind taking a detour or a sidetrack in the middle of this. I think it's important to kind of treat this as much like a discussion as we can. Obviously, if there's a question that I can't get to while we're in the heart of this presentation, I'll try to do that afterwards. And if we run out of time, I will do my best to get to everybody after that. So let me go forward here and talk about get into liability. If you have worked in claims or legal, or really, you probably have heard these phrases before if you have any contact with the maritime industry, and that's Jones Act negligence and unseaworthiness. These two forms of liability go hand in hand. They're seen together on just about every personal injury case that stems from a seaman's activity while in the service of their ship. These two avenues of liability have separate standards for their negligence standard, and they have separate standards for causation. And I'll explain what that means in a second. But the reason that I think that this is pertinent is for a lot of the same reasons that we discussed already. If COVID-19 presents with serious long-term health implications, even to a small proportion of the population that contracts COVID-19, the odds are that some portion of that population is probably going to be, there's going to be some overlap with the portion of the population that works in the maritime industry and contracts COVID-19. So it's not hard to imagine a plaintiff's attorney building a good case or a submissible case regarding serious long-term impacts of COVID-19 that relates to their client's work aboard a vessel. Now, there are a few differences, and these are key differences between the Jones Act, which is built around the Federal Employer Liability Act that was really put into place to protect railroad workers. Well, the Jones Act came into existence after that and incorporates the FELA, and it incorporates the FELA's negligence and causation standard. Unseaworthiness is another claim that has a long history in maritime law. The two of them go hand in hand, and I'll try to do my best to explain how the two of them work together and what your potential risk and liabilities are related to both of them very briefly. So for the Jones Act, if a seaman brings a Jones Act claim against a maritime employer, that is by law their sole legal remedy, their sole statutory legal remedy against their employer. So it's the only law they can take advantage of. It's a federal law, so it applies whether the case is in state court or federal court. And the standard you're going to be judged on as a maritime employer in a Jones Act lawsuit is whether or not you acted with reasonable care to avoid the injury. If you didn't act with reasonable care, what's considered reasonable care under the circumstance, the causation element, the evidence that the seaman is going to have to show to prove that whatever it is that you did wrong in failing to behave with reasonable care caused their injury, that in the Jones Act is what's referred to as feather light. They're only going to have to prove that whatever it is that you did wrong caused their injury in the slightest, it's very, very light. So essentially, if you don't act with reasonable care, you have very easy exposure, very light burden of exposure to a Jones Act plaintiff that brings a suit. Now, unseaworthiness operates on what's called strict liability. That's negligence without fault. So if a Jones Act seaman contracts COVID-19 aboard one of your vessels, even if you did every single thing right and you handled yourself with reasonable care as a company, that vessel can still be considered unseaworthy just for the fact that COVID-19 is present aboard that vessel. Now, if you did everything right and you're not exposed, your exposure is low to a Jones Act claim, the good news for unseaworthiness, especially when it relates to COVID-19, which is, a disease that it's going to be difficult for a seaman to prove that they contracted it in one place versus another. The causation element, the hurdle that a seaman has to overcome under unseaworthiness is much tougher than the Jones Act. They're going to have to prove what's called proximate or direct and substantial causation, meaning that they're going to have to prove that that it's more likely than not that's probable that they contracted COVID and that contraction is a substantial factor of the injuries that they are suffering under unseaworthiness. So the question then really becomes and actually let me go through a couple of examples in case law that I think are going to be used as guideposts by judges in evaluating whether or not a company is going to be liable for a disease that is hard to place, where this person caught it, but ultimately if there's some evidence that they may have caught it on a boat. And I think that a really good place to look is cases that deal with asbestos exposure on vessels and people who had come to be diagnosed with mesothelioma after they had worked aboard vessels that contained asbestos. So the first case I want to talk about is Jackson versus AC Product Liability Trust. This is out of the Northern District of Ohio from 2009, and it's a situation where a Jones Act seaman had occupational exposure to asbestos during his work aboard ships. He eventually died of mesothelioma at a later date after he had left the company, left his maritime employment. Now, the case law says in this situation that exposure cannot be presumed merely because he worked aboard a vessel where asbestos materials were located. This is a situation in this case where the Jones Act seaman, there was testimony that, there was asbestos in the insulation in some of the pipes. My job was to fix some of these pipes, and I was on a bunch of different ships. And if something went wrong with these pipes, it'd be my job to fix them. And that was essentially the evidence of his exposure. The court held that that's not enough. That's not specific enough to reach the causation in a maritime case, that there has to be more than that. Now, the court also held that the jury could make an inference from either direct or circumstantial evidence, meaning that you don't need to have evidence that it's, this room had this amount of asbestos and this is where I contracted it. You can have evidence that says we had asbestos on the boat. I spent a lot of time on the boat and there was asbestos all over the place. And I was there for a prolonged period of time. And that could be circumstantial evidence of that, them contracting mesothelioma in this situation. And that could be enough. But generic testimony about potential exposure aboard a vessel is not going to be sufficient. So then the question becomes, what would be sufficient? My next case I want to show you is Miller versus American President Lines out of the Sixth Circuit in 1993. This is another mesothelioma case where a seaman worked for 23 years at various times between 1944 and 1969 aboard vessels where asbestos was pervasive. And I have that in all caps and in bold letters because this is really a situation where it was just everywhere. There was testimony that came out in the case that it was in the insulation in the engine rooms, the ventilation ducts, steam pipes throughout the crew quarters, that asbestos dust was everywhere. It's not in here in these bullet points. There was even testimony in this case that the crew would wake up in their bunks covered in a thin layer of asbestos dust at times. Now, with that kind of evidence, the court held that that's plenty, that is enough to meet even the high standard of causation for unseaworthiness. Now, I have it in here, as you can imagine, most cases are going to fall somewhere in the middle, and it's all going to be a fact-specific inquiry. How much of this disease or of the disease-causing agent, with COVID-19, how much of these, COVID-19 spreading droplets were aboard the boat, how many people had it, and what was the exposure to those droplets, how long was that exposure? That's all going to be part of the analysis. And then finally, you're going to have to defend your company, or I'm going to have to defend your company and try to prove that you handled yourself with reasonable care. Because so long as you handle yourself with reasonable care under the circumstance, that seaman is going to have to prove a much higher standard of causation. It's going to be much more difficult for that seaman to prove that they contracted COVID-19 aboard one of your vessels, and that was a substantial and proximate or direct cause of their injury. So when we talk about what exactly is reasonable care and how can you best protect yourself, I want to tell you what the best resources for that are, and I think what courts are going to be looking at and what they're going to be asking, what juries will likely be asking, and what you did regarding these resources and their recommendations. So really, what did you do to handle yourself with reasonable care, and what did you do to mitigate your employees' exposure? Now, in the maritime industry, the first thing that most people think is, what's the U.S. Coast Guard saying? And if you go on the U.S. Coast Guard website for coronavirus disease, U.S. Coast Guard gives you a big red banner that says, go take a look at what the CDC says. So if you go to the CDC, and I want to tell you that these are updated all the time. And what I'm going to pop up here is something that is current since, I think, September 17th. And I took a look this morning just to make sure I didn't need to scramble and update these slides. And so far, it's the same recommendations. But here are some of the things I want to talk to you about what the CDC recommends specifically for maritime operations. Now, these guidelines are a bit of a hodgepodge for cruise and non-cruise ships. If you go on the CDC website, there's a section for cargo vessels. But if you click on that section, it has a link that'll just bring you back to this. So it's really one set of standards that the CDC is operating on when it's making recommendations to maritime operators. And the big thing, first of all, is preventative measures. The CDC recommends that you educate everybody on board a ship about signs and symptoms of COVID-19. And what I hope that everybody has been doing is be above and beyond sending out materials to your employees. You ought to be thinking about other ways of communicating, holding sessions where you can have somebody speak to them, holding sessions, you can do it either online, or in person, so long as you maintain proper protocols and distancing, on what people should be thinking about and what signs and symptoms they can be expected to look for. They recommend that crew is assigned to single occupancy cabins with private bathrooms if possible. I think this is the first sign that the CDC understands that, look, not all vessels are designed to deal with this perfectly, to conform to absolute perfect circumstances. No one's expecting you to rebuild your ships so you can have everybody properly socially distanced at all possible times. But I think that maritime employers will be expected to implement the utmost precautions that are possible under the circumstance. So when it says implement social distancing of persons when moving through the ship, I don't think anybody expects you to, widen the hallways, expand the galley, expand quarters, things like that. But I think it is important to remind your employees when they have opportunities to distance among themselves, they should take those opportunities. They should keep space where possible. Now, this next one I've put in bold, and I've done that myself, to instruct people to wear face masks or cloth covering when outside of individual cabins. And this also says, unless work duties prevent their safe use, or necessitate personal protective equipment for hazardous reasons. I've emphasized this because I think the first question that you're gonna have to answer for if you're involved in litigation regarding COVID-19 is what's your mask policy, and how did you educate everybody on your mask policy, and what did you do to enforce it? Now, I say that with some awareness that, a lot of the stuff around masks has become politicized. A lot of people have different opinions on it. This isn't meant to be a commentary on any of that. What I can tell you is, in my experience, none of that's going to matter to a judge or a jury, when the jury's instructed on the law. What they're going to be instructed on is, how did you perform in terms of your obligation for reasonable care under the circumstance? And the measure of reasonable care is going to be, what do the experts say? What do the government guidelines say? And did you follow those guidelines? And the vast majority of government guidelines and experts have been consistent for months now in recommending face masks. So it's going to be really important how you implement those policies. There are a few other guidelines here that I'm going to gloss over so that I don't take too much time, in terms of modifying meal services to maintain social distancing, eliminating self-dining options, those buffet lines, if at all possible, because that could be a spread of disease, discouraging handshake, which seems like something small, but if you can mitigate, person-to-person contact where possible, this could really be a help. Obviously, there are things about hand hygiene, cough etiquette, and giving everybody plenty of hand sanitizer aboard the boats and other equipment. I want to go on to mitigation techniques that are recommended by the CDC. And these slides will be available to everybody, and this website is available to the public, so you can go on and look for yourself. If I'm going a little bit too fast here, you want to make sure to train all of your crew members, all of the people really at your company, on COVID-19 prevention and mitigation. And you want to make sure that there's onboard monitoring, that it's not just monitoring when they get on the boat and when they get off the boat. You want your employees, perhaps captains or the mates or people that are in senior personnel, to monitor it daily to make sure people don't have signs or symptoms. I want to make sure that I also emphasize that you conduct proper screening, both for embarking and disembarking. And you want to have a system that notifies respective national, state, local public health authorities. You are going to have obligations to notify people both under the CDC guidelines. There may also be OSHA obligations you have to consider. So everybody does have a notification obligation. Pre-boarding procedures, very briefly. I think people are now aware to take people's temperatures. If it's at 100.4 or more, the recommendation is not to let that person on the boat. Even if you suspect, somebody that has had contact, with people, even if they don't show symptoms, even if they don't have 100.4 fever, there may still be a good reason to keep them off of a vessel. Just like the question that David Murray brought up. This is exactly what the CDC recommends, but you need to make sure that you are implementing this policy uniformly and consistently. The CDC has some guidelines on how to manage a confirmed case. If you have somebody on a boat, say on a 24-day trip, and they began developing symptoms and they can get confirmed, what should you do? Well, your first option is a full crew change out and then disinfecting the boat. A new crew embarks and resumes operation. The second option the CDC offers is what they call a working quarantine. Essentially, isolate that crew member in their quarters, and then you will really need to strictly enforce all of the other protocols, all the distancing protocols, all the face mask protocols. Once somebody has a positive test aboard one of your boats and you decide to do a working quarantine, you are going to be scrutinized much more heavily for the protocols that you maintain in that scenario. And if somebody else gets sick in that circumstance, you will have to be able to show that you followed handled yourself with reasonable care and followed these recommended guidelines. And the third option is just temporary discontinue of operations. Essentially that is just to park the boat and have them do a lot of the things that they would have to be doing under the working quarantine. So the key takeaways here, under the CDC is that employees need to establish good rules, good protocols, and you need to educate everybody at your company, shoreside, and people that work aboard these vessels of those rules and protocols. You need to make sure that everybody at your company is equipped with the right equipment, with the right tools that they need to deal with this, to mitigate exposure when it's necessary, to be able to judge whether or not somebody has come down with COVID-19 or whether that's likely. And lastly, you need to be empowering people throughout your organization with reporting requirements, with monitoring requirements. Every single person on that boat needs to understand that they have an obligation to not only report when they have their own symptoms, if they're feeling sick, but if they see someone else come down with a cough or behaving as if they may be getting sick, and that person for some reason doesn't report it, it's an obligation of every single person on that vessel, on that boat, to take some responsibility in making sure that the company handles itself with reasonable care. Very quickly, I want to talk about liability shields at the state level. This map is something off of the American Tort Reform Association website. It's current as of early September of this year. And as you can see, we have this patchwork of states. Some of them have executive orders from their governors. Some of them have bills and legislation that has passed. Some of them have a combination of both. And if the bad news for our industry, for the maritime industry, is that these state level liability shield executive orders and statutes are very likely superseded by the Jones Act. It's not going to keep a maritime employee from suing the company under the Jones Act, which is the uniform and federal statute by which they can sue their employers. And also, even if they're not superseded by the Jones Act, there are still exceptions in all of these, generally for gross negligence, misconduct, willful or wanton conduct, and reckless and intentional infliction of harm. So no employer is ever going to be shielded from an injury they cause to one of their employees through gross negligence, through willful or wanton conduct, or through reckless or intentional infliction of harm. And I just want to also remind you that regardless of how this applies to a Jones Act or unseaworthiness claim, this is going to have absolutely zero impact on your maintenance and cure obligation. That has nothing to do with a potential liability case. Now, at the federal level, right now, there is a bill that has been brought forth in the Senate, and I'll talk about how it's been co-sponsored and where it's at. Right now, this is called the Safe to Work Act. And if this becomes law, it will be the exclusive federal cause of action for anybody suing an employer or trying to sue an employer over injuries related to COVID-19. This is likely to, I would say it may supersede the Jones Act. I think it likely would supersede the Jones Act if it passes. And as you can see from these bullet points, this thing contains the most protection for businesses. I think it's about as much as possible. There will be procedural hurdles to filing suits, where somebody's going to have to file an affidavit from a non-treating physician to certify causation. They're going to have to file something talking about where they were, and all the people they contacted with 2 weeks prior to symptoms. And they have to include certified medical records just before they even file. Then even if they get past that, they're going to have to clear a hurdle of a standard of proof of clear and convincing standard instead of a typical preponderance of evidence. So this is a high standard of proof. They're going to have to prove willful misconduct or gross negligence, and they're going to have to prove that they did not make reasonable efforts to comply, that the company didn't make reasonable efforts to comply with applicable governance standards and guidelines, which we just talked about earlier. This is an extremely high bar, and if this act becomes law, this is going to offer a really nice amount of liability protection. Now, the bad news on that, and there are also additional disincentives. Actually, there's involved in the act, the employer actually can go after for punitive damages against somebody bringing a case if their case gets thrown out for being meritless. The Department of Justice can go after attorneys or unions that put together lots of these claims if they're meritless, and you can even seek attorney's fees. Now, this was introduced in July of 2020. There are 19 co-sponsors in the Senate. If you read the news or you follow kind of the way that that our political system works right now, the Senate is controlled by the Republican Party, the House is controlled by the Democratic Party, and the president is a Republican. If this does make its way through the Senate, and it hasn't yet, it's going to have to also pass the House. And there is always a possibility that the House flips to Republican control, that the White House stays Republican after the election. And if that's a scenario that happens, it is very likely that something that either this or something very close to this passes and becomes law. Short of that, what I would take this is really just a negotiating position. So going forward, what is it that you should be thinking about in light of everything that I just talked to you about in dealing with this in terms of your long-term safety ramifications and your long-term exposure ramifications, and even your short-term exposure ramifications regarding maintenance and cure? The questions you should be asking is, because this information is constantly evolving and the recommendations from the CDC are constantly evolving, what is it that your company is doing to keep up with these evolving standards? And more than that, are you documenting what you're doing to keep up with these evolving standards? Because that is going to be something that you're going to have to answer for if you're sued and you're trying to convince a judge or a jury that you handled yourself with reasonable care. Is how up to speed are you on everything when things change as much as they had from COVID, with recommendations regarding COVID-19? You're going to be asked, are you implementing these policies that you have? Are you implementing them uniformly? Are you implementing them across all the boats, across all the people in the different positions on those boats? Are you implementing them for shoreside staff as well? And the other question that you're going to have to think about is, are you implementing these rules, or are you just making recommendations? There's nothing that a plaintiff's attorney likes to hear more in a deposition than, yeah, here's our rules and here's our policies, but when we were out there on the boat, that's not really the way that it worked. You want to make sure that if you have rules in place and you have policies in place, you want to make sure that your employees understand that it's their responsibility to implement these rules and precautions in the same exact way that they implement other safety rules, precautions, and protocols. This is just as important. You have to ask yourself, are you empowering all these employees at all levels in the chain of command? We talked about this before, but you should really be thinking about doing your best to make sure that everybody aboard a vessel has a sense of ownership for keeping that vessel as COVID-free as possible. And if there is a positive test, for mitigating the impact of a COVID diagnosis aboard that vessel. You should be considering a symptom check and a questionnaire at boarding and departure from a vessel. And on top of that, I think you should be considering a symptom check and questionnaire every single day that a group of people is aboard these vessels. And this obviously pertains to line boats, not necessarily harbor boats, although sometimes harbor boats have crew that stays on the vessel as well. If you have crew that stays on the vessel and doesn't go home at the end of the night, they ought to be completing a questionnaire every single day so that you can be sure that somebody who is asymptomatic when they get on the boat doesn't develop symptoms day 2, 3, 4, 5, or 6, and you don't know about it. And then you have, which could lead to an outbreak. You should be asking yourselves, what are your protocols, or what are your plans that are in place? What's your company decided to do for when somebody develops COVID systems while the vessel is underway? I showed you the 3 options that the CDC gives you. Using those options would be a good guidepost. Using some combination of those options could also be a good guidepost. But so long as you have something in place that shows that you took this seriously, you had a plan in place, and that you followed the recommendation of the guiding government agencies. As testing becomes cheaper, more available, less invasive in terms of saliva tests, as opposed to these swab tests where they have to get shoved up people's noses very uncomfortably, you should be considering expanding testing every single person prior to their boarding and departure from one of your vessels. Now, again, this may not be feasible if there's not a test that can give you quick enough results, but I know that there have been some tests brought to market that give very fast results, sometimes 15, 30 minutes, which should be considered if you can get your hands on those in an economically viable way for your company. And even in this case where a test doesn't get you results until 1 or 2 days later, you ought to consider using one of those tests for everybody that boards one of your vessels for a 28-day trip, because even that amount of knowledge can be very helpful if if a positive test come back 3 days later and that person isn't experiencing symptoms. It can help you mitigate that COVID spread. And it'll show later on to a judge or a jury in a potential case that you did a nice job, that you did everything you could and handled yourself with reasonable care to try to mitigate exposure and to try to keep everybody on that boat safe. And lastly, document everything and retain your documents. This is something that I think is advice for really anything that you do in your operations, but especially involving your precautions and your policies related to COVID-19. Because again, you may find your company may find itself in litigation years down the line, and you cannot rely on people's memories or on institutional memories on how you handled yourself to prove that you handled yourself with reasonable care. It is crucial that you document everything and that you have a good document retention protocol developed at your company as well. And we have somebody who specializes in that kind of thing at Fox Smith that can always be of service to you if you need help developing protocols like that. So I don't see any other questions, and I've hit looks like a minute over the hour here. I'm willing to stick around if people do have questions, and it's up to Frank if we want to do that. Otherwise, I am available. You should have my contact information. If anybody needs to talk to me, wants to email me, please don't hesitate to do so. There's no such thing as a bad question or a stupid question in a situation like this, and there are a whole lot of unknowns.
Yeah, thank you, Stas. Thanks for laying out that information and knowledge. Definitely a solid foundation for operations during this time. I jotted down your 4 bullet points of establish, educate, equip, and empower. Wanted to, from the Waterways Journal, I wanted to offer another thanks to attendees, whether you're at home, in the office, in the field, or wherever you're working these days. And also a special thanks to Fox Smith for sponsoring this session. People be sure to visit the virtual expo hall, open until 4 today, and then also tomorrow from 10 to 4. Engage exhibitors and network with colleagues in the networking lounge, and look forward to the sessions for the rest of the day. We have webinars now until 1:30, and then we have a session focused on Tier 4 engines and related supply chain issues that begins at 2 p.m. And if there's any more questions, people could jot those down or contact Stas directly. And thanks again for your attendance.
All right. Thanks very much. I see there are no questions, so I'm going to go ahead and sign off.
Okay. Thank you.